This Honorable Court of Appeals of Tennessee is now in session.
Good afternoon and welcome to the Tennessee Court of Appeals. First of all, I want to thank counsel for agreeing to hear this matter by Zoom. We've been doing this now for, approximately a year and a half, and it's proven to be the best way to keep the cases flowing through this very difficult time. Want to do a couple of things before we get started. First of all, I want to make you aware that if we have any technical difficulties, and we certainly don't expect to have any, everybody just remain calm, and we'll make sure that everything works itself out. Nobody will be prejudiced in any way if we have any technical difficulties, and we'll certainly take care of those. Before we start, I want to introduce our panel: Judge Kenny Armstrong from Memphis, Judge Karma McGee from Savannah, and I'm Steve Stafford from Dyersburg. We will conduct the oral argument today as if we were in the courtroom. Same procedure and protocol will apply. That means each side gets 15 minutes to make its oral argument. If you're the appellant and you have reserved time previously with Mr. Hivner, you'll receive that time for rebuttal. Mr. Hivner, anything we need to take up before we get started?
No, Your Honor.
You may call the case then.
All Access Coach Leasing, LLC versus Jeff McCord, Commissioner of Labor and Workforce Development, State of Tennessee.
All right. Thank you, sir. We'll hear from the appellant.
Thank you, Your Honor. Brett Carter of the Nashville Bar, and I represent All Access Coach Leasing in this appeal. I'm going to argue three things today. First, that the Chancery Court misapplied the precedent from this court and the legal analysis in the HRP of Tennessee case, which we have cited in our briefs, in finding that the bus drivers at issue in this case should be treated as employees and not as independent contractors. Second, we're going to also argue that the 2010 appeal process that was adopted by the General Assembly for appeals of worker classification issues violates a taxpayer's right to due process, both under the Tennessee and U.S. Constitution, because it does not provide for a meaningful, fair, or an impartial review in cases such as this. And then finally, I want to argue that under Tennessee Code Annotated 50-7-207, that both the common law and ABC tests are met here, such that the bus drivers that are at issue should be treated as independent contractors. Just briefly on the facts, All Access Coach Leasing is a motor coach leasing company that leases buses to entertainers such as Blake Shelton, Kenny Chesney, Alabama, for multi-city, multi-state tours. Oftentimes those tours will have their own bus driver, but if they don't, All Access maintains a pool of drivers that are licensed, that are trained on federal safety standards. And so if there is not a driver assigned already by that tour, then All Access will work through its pool to identify somebody to drive on the bus tour, assign somebody to the tour. They have the option of taking it or not taking it, and that's clearly in the record. And then from there, at that point, they are then handed off to the tour. The tour coordinates with them. They pick up the bus at the All Access facility, meet the tour, pick up the people, go on the tour, and then return at the conclusion of the tour to return the bus. And when they're picking up and returning the bus, it's our position that they're doing that on behalf of the tour company, because the tour company is responsible for that particular bus. While they're out on tour, there's no obligation, and they do not, in fact, that was the testimony before the appeals tribunal, they do not have any obligation to communicate with All Access Coach Leasing. They don't contact All Access Coach Leasing. All Access Coach Leasing is not in a position to control them while they're out on the tour, because they just don't check in. They leave and then come back, and those are the only points at which they have a communication with them. In this case, there was an audit of the treatment of these workers these drivers as independent contractors. At the appeals tribunal ruled for the taxpayer and found that they should be treated as independent contractors. And then it was appealed to the single person commissioner's designee that overturned that decision, and that led to a subsequent appeal to Chancery Court and to where we are today. So we submit first that when you look at this case, this court has addressed this very issue before in the HRP of Tennessee case. The Court of Appeals addressed a situation where there were nurses assigned to hospitals by a staffing company. While those nurses were at the hospital, they were under the control and supervision of the hospitals. There were certain policies and procedures of HRP, the staffing company, that those nurses had to apply to. They got paid bonuses. They did performance reviews by HRP of Tennessee. There were various activities and functions that HRP did, even though the ultimate control of the nursing was held by the actual hospital facilities. And so in that case, the department came before the Court of Appeals and said, based on this laundry list of activities, well, HRP of Tennessee, they're in control of these nurses and they should be treated as employees. But the Court of Appeals rejected that position in that case. The focus of the statute is on that the employee or the worker has to be free from any direction control in connection with the performance of such service. And what the Court of Appeals held and concluded is that the focus of the analysis is on who's in control of the actual service that's being performed. And so, even though you had this laundry list of activities that HRP of Tennessee, as the staffing company, did require of the nurses, it didn't change the fact that the actual performance of the nursing services was not controlled by them. And the court ultimately concluded that they should not be treated as employees, but instead be treated as independent contractors. In that case, the court said the department presented no evidence that the nurses were controlled either vicariously or directly in the performance of their duties as nurses while working at the various medical facilities to which they were assigned. And that's particularly relevant. And in that case, in that very paragraph, they highlight the performance of the services, italicized, because that's the focus of the court's analysis, and that's what the court held. In this case, when the trial court looked at this issue, we argued this very point. But the trial court, in their conclusion of what we argued was, well, they summarized our argument as that we were arguing that they should not consider all the facts. Well, that's not what we argued at all. What we said is HRP of Tennessee, that decision said you look at the whole circumstance, but the only facts in determining who has control are the facts that relate to who's in control of the services while being performed. And that's relevant here because when these bus drivers went out on the tour, the record is clear. They did not communicate with All Access. All Access did not tell them, this is where you're supposed to drive. This is the route that you're supposed to take. They didn't have any of those things. Now, the department tries to rely on the manual. There was a manual that All Access had, and that manual really is a collection. 90% of that manual is a collection of the federal rules, federal mandates of what bus drivers are responsible for doing, in terms of safety, maintenance, drug testing. And so they have all of these different checklists and provisions that they do, but they're not policies and procedures that are adopted by All Access. Those are federal requirements that apply to a driver, and the federal regulations, as we pointed in our brief, are applicable regardless of whether a driver is an employee or an independent contractor. So they acknowledge you can have independent contractors who still fall under these requirements. And so we submit that even though there is a manual, there were policies and procedures in the HRP of Tennessee case. There were instructions that HRP imposed upon the nurses. Those are the same types of things that the manual is doing in this case, is providing the safety instructions. Now, there are some things in the manual that provide for you have to take off the sheets, or you have to wipe down the counters or take off the trash. But we would submit that those are not an imposition of control. Those are routine and type functions that are just put in there, but it's not a mechanism that's controlling the performance of the driving services. And we think that has to be the analysis of this court in applying HRP of Tennessee. And we submit that the trial court simply misapplied that. We didn't tell them to disregard the facts. We said that the facts that are relevant are the facts that relate to the performance of the service. And so all of these
What about the pre-trip and post-trip checklist and the obligations imposed on the driver by those?
Yeah, and so we would submit, when you look at those checklists, most of those requirements are checklists that are federal mandated safety requirements. They're not, all access doesn't say you have to perform these functions. Those are federally mandated maintenance checks that have to be performed before and after a bus. And so that's the implementation of those federal rules. Again, all access, has an obligation, as a bus company, regardless of whether these are employees or not, to make sure that those bus drivers have an obligation under federal law to make sure that those maintenance activities take place. And so it's just a really memorialization of what federal law already imposes on those particular drivers.
Are the drivers themselves required to attend mandatory meetings?
Yes, under federal law, there have to be, and we provided sites in our brief, and so, but there are federal, there's in the record the excerpts from the federal rules that require these training sessions. And what federal law does is it requires the bus owning entity to be the party that administers that. So, for example, Your Honor, if Blake Shelton brings his own bus driver to All Access and says, this bus driver is going to drive this bus, well, All Access still has to make sure, one, that they have a proper license, two, that they have received the proper training. So federal law imposes those obligations on All Access. It's not All Access who is creating these standards that ultimately.
Are you suggesting that if Blake Shelton brought his own driver to drive an All Access coach, that Blake Shelton's driver would have to go to these mandatory meetings as well?
I think what they would have to ensure, All Access would have an obligation to ensure that driver, I think the record would show that they would then create a folder on that driver to make sure he has a license, to make sure that he'd been drug tested, to make sure that he had the applicable federal training. All Access provides that training as a product of its obligations are under federal law, but they would have to ensure before that driver would drive the bus that driver has the federal training that he ultimately is supposed to have under federal law.
Isn't there a distinction there, though, between making sure that a person is qualified and meets the requisite requirements to drive and requiring mandatory meetings to provide that training?
Well, I would say, Your Honor, it's the mechanism that All Access has implemented to ensure that that training takes place, and so I think they have a way to make sure that training takes place, and that's the way that they implement the federal law. If those, they provide the ability to do that training, provide the materials. But we would submit, Your Honor, that that's still an obligation of federal law and is not some way in which All Access is exerting its control over the performance of the service. And so that's why I think the focus is, are they exerting their control over those drivers when under federal law, they're mandated to make sure they have that training. I would say the way that they implement that training shouldn't change the outcome of whether they're actually treated as independent contractors or employees under the HRP of Tennessee analysis that focuses on the performance of the service. And I see that I'm out of time.
Okay, thank you. We will hear from the appellee.
Hey, please, the court. My name is Kristen Kyle Castelli, and I'm here on behalf of the Department of Labor and Workforce Development. The present case involves the department's administrative classification of All Access coach and leasing drivers as employees instead of independent contractors. To guide the court, I plan on addressing the following 2 points. First, All Access failed to carry its burden of proof under the ABC test that drivers working with a company were independent contractors. And secondly, I will address All Access waiver of any constitutional challenges to TCA 57304E. Alternatively, their argument is without merit. Every employer receiving services by an employee, as defined by 57207, must make contributions to the Unemployment Compensation Fund. At the time this case was decided, 2 tests were used to determine if a worker was defined as an employee or an independent contractor. Those tests are the ABC test pursuant to TCA 57207E and the common law test pursuant to TCA 57207B2. Under the ABC test, the employer has the burden of proof to establish all three parts. If the employer fails to meet their burden, the worker is an employee and contributions to the unemployment compensation fund would be due. If they meet their burden, the analysis under the common law test would still be required. For brevity's sake, today I'm just going to focus on the ABC test. As the name implies, the ABC test has three elements. First, the individual must have freedom from control and direction in connection with the performance of their service. Secondly, the service is performed either outside the usual course of the business for which the service is performed, or is performed outside of all the places of business of the enterprise for which the service is performed. And thirdly, the individual is customarily engaged in an independently established trade, occupation, profession, or business of the same nature as that involved in the service performed. Here, the commissioner's designee found that All Access failed to meet its burden in establishing that the drivers were free from the company's control and direction under Part A. The commissioner's designee found that All Access exerted primary control over the drivers by integrating the drivers into its business operation, requiring meetings, mandating policies in its handbooks that the drivers were required to follow, ensuring drivers performed to the satisfaction of the tour companies and complied with federal safety regulations, and established policies to protect the company's investments. As the Chancery Court noted, the buses themselves served as tether between the company and the drivers, an investment All Access has sought to protect. The department relies on the holding NHRP of Tennessee that Part A focuses on the company's control in connection with the driver's performance of service. All Access fails to account for the finding that the commissioner's designee actually found that All Access had exerted control directly while the drivers were driving. The pre and post trip duties, whether or not those were ancillary, is tied, but as long as they found that there was direct control while the drivers were physically driving the buses, then whether the pre and post trip duties don't carry as much weight. And the commissioner's designee did find that All Access exerted control, direct control over the drivers while they were driving. Unrelated to federal regulation or
what were the facts that supports a conclusion that they exercise direct control over the drivers when they're driving?
Yes, Your Honor. The handling, All Access's policies required the drivers to handle mechanical issues in certain ways, to follow their policies and procedures governing citations and accidents, to limit the company's own liability. They had cleaning procedures that were required while the drivers were actually on the road. But I think the most telling of all was an example that Hugh Howell, who had been a driver with All Access for 15 years, testified to. He stated that there was one time when he was in the Sierra Nevada mountains and there was a sign that required snow chains. A state trooper pulled him over and said, "You need to kind of keep moving on down the road." And Mr. Howell said, "I can't, because my company's policy, the All Access manual, forbids me from driving when in conditions that required snow chains because of the investment of the bus. It was too dangerous for the bus to actually proceed on those roads." So Mr. Howell actually sat on the side of the road for 6 to 8 hours waiting for the roads to be salted before he would proceed down the road. It was directly because of All Access's manual that he stated that that's the reason why he waited. It had nothing to do with federal regulations. Federal regulations require that snow chains be equipped on buses of this size. And it wasn't the tour company, because I assumed they really wanted to get to their next gig. But that was direct control, Your Honor. All Access is controlled to ensure the buses remain protected. Does not mean that the tour company itself didn't have some type of control. I mean, they dictated the routes and the times and dates that they needed to be places. But I think that's the reason why the commissioner's designee found that there was dual control, that All Access controlled the drivers to the extent necessary to control the buses and their investment in the company, and the tour companies controlled the drivers' obligations to the extent to meet their tour demands. All Access also retained the control over the drivers to terminate their service, even in the middle of a tour. Originally, All Access argued that they could only replace a driver in the middle of a tour if that driver was ill or if the tour company requested the removal. Mr. Hitchens, however, stated during the hearing that he had actually personally replaced drivers at All Access's request in the middle of a tour, and that he himself had been replaced without his own tour's knowledge by All Access after he complained that All Access had failed to follow federal regulations. Mr. Howe also stated that he believed that All Access retained the right to termination if they did not believe that services were being performed to their expectations. Drivers, as we've been talking about for the pre and the post trip, drivers were expected per the All Access manual and handbook to conduct certain pre-trip inspections. As we noted in our brief, the pre-trip inspections are actually federal regulations that are required after every shift, not before the shift begins. So it seems that should not necessarily be a requirement for the drivers based off of a federal regulation. It's All Access policy to ensure that their buses are going off the lot in good condition. And the driver's post-trip duties also included winterizing the buses, using dump stations for the water tanks, cleaning the interior, checking on maintenance issues. And there's really, contrary to All Access's assertion, there's really nothing in the record that reflects that the tour company was responsible for requiring those post-trip duties. And I don't believe All Access even argues that those specific ones were required by federal regulations. And drivers were instructed not to leave prior to performing those post-trip duties. They could be verbally addressed or written up for their failure to do so. The control exerted while the drivers were driving, the pre and post-trip duties and the mandatory meetings in combination serve to demonstrate that All Access did exert direct control over its drivers, and thus they would be considered employees instead of independent contractors. Under Part B, the commissioner's designee found that All Access also failed to meet its burden, that the services, specifically those pre and post-trip duties, were performed at All Access's place of business. And so the commissioner's designee found that All Access failed to meet its burden under that prong as well. Under Part C, the question is whether the individual is customarily engaged in an independently established business of the same nature. Once again, the commissioner's designee found that All Access failed to meet their burden under prong C as well. The question is not simply whether the driver could engage in a similar business, it's whether or not they did. In HRP of Tennessee, this court cited that 98% of nurses that were working with the company were customarily engaged in working for more than one agency. The same thing with Tennessee Supreme Court noted in the Bayer Company case is that the hoppers were actually working for more than one company on a regular basis. Here, the commissioner's designee found that All Access failed to meet its burden because the drivers had been working there for 7, 11, 15 years. Very few of them worked for different companies. I think only one actually worked for more than one company on a regular basis. There were certain drivers that were assigned buses. They kept their belongings on the bus. They did everything in their power not to be removed from that bus because that was their coach or their workplace. They had gotten accustomed to it. Turning to All Access's constitutional argument, All Access has waived any challenge to the constitutionality of the appeal procedure contained in TCA 57-304E because they failed to properly raise the challenge before this current appeal. In its brief, All Access presents the challenge as an as-applied challenge but All Access failed to raise their challenge at either the administrative or the chancery court level, despite the clear language that was required in 57-304. In its petition for judicial review, which is required to be with specificity, All Access does not mention TCA 57-304E. It does not claim its due process rights were specifically violated. It does not claim that the commissioner's designee's decision was actually impartial or biased in any way. The Chancery Court outlined All Access's arguments and did not note that any of those, any challenge to 57-304. And unless the statute is clearly unconstitutional on its face, constitutional challenges to the validity of a statute may not be raised for the first time on appeal. Thus, the state's position is that All Access's constitutional challenge should be deemed waived. Their arguments also lack merit. 57-304E is presumed to be constitutional, and any doubt should be resolved in favor of the statute's constitutionality. It is a very high burden, as your honors are very aware, in order to do either a facial challenge or an as-applied challenge, because of the presumption that those statutes are constitutional. All Access challenges the opportunity to be heard in a meaningful manner, but they receive due process in this case. Administrative procedures do not have to follow or require the same level of impartiality as Article 3 judges because of the overlap of functions in an administrative hearing. Further, the administrative arbiters are entitled to a presumption of honesty and integrity for constitutional due process purposes. Procedures exist for the disqualification of administrative arbiters. They can be removed if there is concerns about a pecuniary interest or conflict of interest, prior personal abuse or criticism of the company, or actual bias. Not only did All Access fail to establish this burden at the administrative or the chancery court level, the company failed to actually allege on appeal how exactly the commissioner's designee in this case should have been disqualified because of any bias under any of the prongs that we have outlined in our brief. For these reasons, the Department of Labor and Workforce Development are going to ask this court to affirm the Chancery Court's order that the commissioner's designee's decision was not arbitrary or capricious and was supported by the evidence that was both substantial and material in light of the entire record, that there was no violation of the constitutional or statutory provisions. And further, the department asks this court to find that All Access has either waived its constitutional challenge or that their argument is without merit. Thank you.
Thank you. We will hear from the appellant in rebuttal. You're muted, Mr. Carter.
Thank you, Your Honor. So addressing a couple of points, Your Honor, in terms of the waiver, we think that there was a constitutional violation. That's not a part that I got to as part of this, but ultimately the case that the state cites, the city of Memphis versus Shelby County, says that a waiver cannot exist for a facial constitutional challenge. And what we submit is that this particular statute, and everything that you heard from the department as part of that goes back to, this is what the findings of the commissioner's designee was. This is what the findings of the commissioner's designee was. This is what the findings of the commissioner's designee was. Well, the commissioner's designee was not at the hearing where the actual witnesses provided testimony. And the appeals tribunal, the party who actually heard this particular case, ruled in favor of the taxpayer, only to have that particular decision overturned by the designee of the commissioner. At that hearing, it was All Access versus the commissioner based on his assessment. And so when one party can unilaterally overturn the independent reviewer and finder of fact, that's where in this particular case, Your Honor, that's where due process, there's no meaningful hearing. There's no reason to go to the appeals tribunal if the commissioner's designee can listen to the record and make all kinds of findings of fact that ultimately, when you go to the trial court, when you go to the chancery court, receive deference as findings of an administrative agency, it puts a taxpayer at complete disadvantage. This is completely inconsistent with anything else that we see in Tennessee tax law. For franchise and excise tax and sales and use tax disputes, you have a new hearing at the trial court level. For property tax cases, you get a new hearing at those are all cites in our brief. But in unemployment tax cases, you go through an administrative process, you win, and then the appeals tribunal or the commissioner's designee overturns everything and makes all these findings of fact that ultimately form the basis and receive judicial deference at the chancery court level. That's not due process, Your Honor. That's not meaningful. That's not fair, and it's not impartial. I mean, the hallmarks of what a party should be entitled to are ripped away. This is not a provision that has existed for years and years and years. This was a 2010 change, as we point out, where there was a backlog in the appeals process at the unemployment at Department of Workforce and Labor and Development. And so they said, well, we're going to change it to where it's a one-person review panel at this point. And so they basically changed it from a three-person panel to a one-person commissioner's designee. And so both of the cases
let me ask you before your time expires. Do you claim that you raised this issue?
Yes, Your Honor. I think we this included in our petition. And I mean, in
okay. Tell me how it's included in your petition.
I see my time is running out.
That's okay. You can answer the question.
Yes, Your Honor. I mean, a constitutional challenge. It was included as a count in our petition in our case. It wasn't specifically cited as due process.
The trial court, or who was it?
At the trial court.
Okay.
And if you read in the holdings and findings of the Chancery Court also include a determination that if they found that the provision or that there was no statutory or constitutional violation, it was before the court. But again, it's a facial challenge, and so
you've answered my question, Mr. Carter.
Yes, Your Honor. Thank you.
All right, folks. We certainly appreciate your argument. We will take this matter under advisement and will attempt to render an opinion at the earliest possible time. Again, we appreciate your participating in this via Zoom. We appreciate Mr. Hibner and the AOC staff for making this possible. Mr. Hibner, if you would recess court to the call of the next case, please.
This honorable court is now in recess until 2 p.m.
Thank you.
Thank you.
All right, great. And I'm going to go.